Morning, and thank you for joining this Enghouse Interactive webinar on General Data Protection Regulation, or GDPR. My name is Rupert Adair, Product Director with Enghouse Interactive. Enghouse Interactive is a leading supplier of a broad portfolio of customer interaction solutions, including contact centers, attendant consoles, and quality management systems. With us today, we have Robert Bond, partner at Bristows International Law Firm, a leading authority on data protection and an expert in many fields of technology-related security. I'll leave Robert to introduce himself in a moment. However, first, some housekeeping tasks. We'll take questions via the webinar chat facility, and depending on the nature of these, Robert may handle these during the session. We aim to have most questions dealt with at the end of the session. We'll be recording the session, and this will be posted to the Enghouse Interactive website. Attendees to this call will automatically have access to this. Not only those not on this webinar will need to register via a link distributed following the webinar. Now, let's proceed with the topic of the day, General Data Protection Regulation, or GDPR. And it's my pleasure to hand over to Robert Bond of Bristows. Robert, over to you.
Thank you very much, Rupert. And we're going to talk about debunking GDPR. There's a lot of information out there that says it's all about 25th of May. And then I'll hand over eventually to Rupert to look at Enghouse's approach. So the GDPR, you can't have not heard of it. It comes into force on the 25th of May. And it's not too late to get on the compliance journey if you're not already on it, and I'm trusting that most of you will be. As Rupert said, I'll introduce myself, and very briefly, I've been doing data protection for 30 some odd years. I started playing around with it in the early 80s and thought it might be interesting, and now I realize it's taken my entire life over and I do nothing else. And I'm with Bristows, and we have been acting for a lot of significant brands that you'll recognize there, dealing with their GDPR compliance for some while. And we're continuing to act with a whole range of organizations in terms of what they are trying to put in place now. The ICO, our Information Commissioner, some while back produced guidance about what you need to be thinking of in order to get on the compliance journey. First of all, are you a controller, i.e. making decisions in relation to personal data, or are you a third-party processor acting on the instructions of a controller? And it may well be that where you outsource some of your functions, you're the controller, and that third party you outsource to will be a processor. Rupert's going to say a bit later on the who, what, when, where, why, and how of personal data, but we need to know, what do we hold? How sensitive is the data that we've got? What volumes of data do we have? Why do we have it? GDPR is going to drive us to be clearer in our communications to individuals of their privacy rights and the way in which we manage their data, and also the legal or lawful bases on which we are relying on the right to process, which is not all about consent. We keep hearing consent, but I'm going to come back later on and say it's not just consent. Data breaches are now a mandatorily notifiable issue where it may have a significant impact on individuals. We need to put in place data protection impact assessments, which is a completely new process for many organizations. Many organizations, whether they're a controller or a processor, may have to mandatorily appoint a data protection officer, and I'll come back to this. And then, of course, it's a breach of the law to transfer personal data outside the EU, or more correctly, the European Economic Area, to other countries that are not deemed adequate by the European Commission. It is not a point-in-time compliance issue, and our ICO has made it clear in her myth-busting blogs, which are really worth reading, that it is not the Y2K that we all remember from years ago. This is a journey. The 25th of May is part of the journey. It's not the end of the journey. And I want to make it clear for those of us who are not perhaps completely on top of GDPR, it is important to start the journey now, even if you are still completing it after May of this year. GDPR lays down some principles about what you can do with people's data. They're actually exactly the same principles as we have under the current law, under the Data Protection Act. We just have some new words like accountability, transparency, data minimization, but it's nothing different to what you already should be operating under now. So it's not the end of the world in trying to head on that compliance journey. The grounds for processing, again, not much different to what we have under the current law, although there's a greater opportunity to rely on legitimate interests, and I'm going to come back to that in a minute. Where you rely on consent as the purpose for which you're processing data, remember that under the new law, it must be as easy to withdraw consent as it is to give it, and that might drive you in your analysis to consider whether consent is really the appropriate mechanism, because we don't want to find ourselves in a situation where you are dealing with an individual who consents 1 minute and then a nanosecond changes their mind. And that's, something that we have to try and work through. But we have to certainly be plain language, intelligible, concise in the way we convey to individuals what we're doing with their data. That means that we have to go back and look at those privacy policies we have on our websites, written by people like me as lawyers, which are more designed to obfuscate and confuse the individual than they are be transparent about them. And I shouldn't be the first to admit that, but we do see 40-page privacy terms which nobody, not even a lawyer, could understand. So do go look at your privacy notices and actually say to yourselves, are we doing what we say we do? Is this actually a privacy policy that's relevant to our business, or did our development team cut and paste it from somebody else's website? Just as a great example of that, I was acting for an online dating agency a little while back. They went live and then asked for legal advice. And when I went in, the chief operating officer said, before you say anything, we have a privacy policy. And I said, I know you've got a privacy policy, but it isn't yours, is it? Let's take a look at it. You're an online dating agency and your privacy policy says, we love your privacy so much, we will reveal your information to no one. Not a great way to get online dating. Anyway, also, we have to have language that is capable of being understood by the person you are communicating with. And maybe if you're dealing with teenagers, because you're a Snapchat or you're a SpongeBob SquarePants, etc., we start to need to look at iconography or visuals or cartoons. I think this is where the marketing team and the communications team can actually be more creative for you. Legitimate interests. I just want to spend a couple of minutes on this because it is important for your business to recognize that it's not all about consent. There are lawful grounds such as contract, terms and conditions that may justify what you're doing with people's data. Or it may be that it is in your business interest to make those calls, to make those follow-ups, because it's added value. And helpfully, GDPR actually says there, direct marketing is a legitimate interest, and yet we'll have read everywhere you can't direct market without consent. Not true. Of course, you have to have a connection with the individual, and it must be within their reasonable expectation that they would get that sort of call or be offered that sort of service. But then you might well be calling and following up because it is part of an aftercare sales relationship, or you are trying to establish that the person is who they say they are, and you're using technology to protect the network to stop fraud, to ensure that somebody who has been identified as an undesirable customer is not coming back on your site or your business again. So cookies can be a perfectly legitimate tool, but to carry out a reliance on legitimate interest, you've got to carry out an assessment to see whether on balance your business interest doesn't overreach the rights of the individual. And we call that a legitimate interests assessment, or LIA. And there's a group in the UK called the Data Protection Network, which represents privacy managers from organizations like TUI and L'Oreal and Google and Barclays Bank and Age UK, where we've been working on guidance for businesses on how to use legitimate interest legitimately. And if anybody is interested in that, by all means email in, and I can certainly supply it to Rupert and the team so they can send it out to you. But it does have an example of a legitimate interest assessment template, and we're seeing a lot of businesses analyzing, is this the route we go? And before I move on to the next slide, where we look at data subject rights, I just wanted to remind you that individuals' rights, which we're going to talk about, some of them only apply where you collected their personal data under contract or with consent. So, for example, as we will see on this slide, the right of erasure, or the right to be forgotten, and that right of portability, in other words, to have your personal data ported from the platform it's on to potentially a competitor's platform, do not apply where you obtain the data with legitimate interest. So that's an interesting route. Not that legitimate interest is the silver bullet. It's not the get out of jail free card, but I would urge businesses to refocus on the lawful, or as one of my clients calls it, the awful grounds for processing. But from May of this year, subjects are going to have enhanced rights, some of which are already out there under the current law, right, like the right of access, the right to know what you are processing about me. And if you've ever been subject to an access request, you'll know it's never a happy person that wants to know what you've got about them. It's an aggrieved person. And you need to have a process in place to stop the crisis becoming a disaster. Now, there's something we already have under the current law, but we've never had the right of erasure. We've never had the right of portability. And so you need to ask yourselves, do we have an SOP? Do we have a process for managing, where we are a controller, these types of requests coming in where we can't charge the individual for responding to them? And in some cases, under the new law, a subject access request has to be responded to in 30 days. That's not working days, that's calendar days. It begs the question, do we actually know where all the data is to be able to respond to the individual if we are supposed to respond to them? And failing to comply with data subject rights is one of those breaches of the new law that can give rise to these massive fines you've heard about, like 4% of your global annual turnover. So data subjects who are unhappy have the potential to make your life hell. So anticipate there's going to be a spike by May of this year from individuals who will be told by consumer rights groups, you can do this stuff and you can find out what somebody's got about you, and if they don't respond, you can report them to the regulator. Be prepared for it. And also, to the extent that you are using automated decision-making technology, or you are profiling a customer, they have a right to object to that type of activity and a right to understand the methodology that you apply to an outcome if they feel they've been discriminated against, where there is no human intervention. Now, I suspect in the majority of cases you'll say, well, we use technology, but there is still human intervention. So this is not automated decision making. But there is a lot of cookie technology, a lot of online retail profiling where it is entirely an automated outcome, as might be used in, say, the insurance sector based on your driving habits. And I'm sure we will end up with that with connected autonomous vehicles and that sort of thing going forward. So don't forget subject rights. Also have an eye on those instances where you outsource personal data that you are responsible for as a controller. GDPR makes it an offence not to have a contract in place with the third party that you are engaging with, who may be at some point touching the personal data that you are responsible for. And the buck stops with you as the controller, although the law does make the processor liable for certain aspects of the new law. And that is coming as a surprise to a lot of cloud providers, a lot of vendors, particularly those outside the EU, that have suddenly realized actually we are processing EU citizens' data, even though we have no business in the EU, we are caught by this new law. Wow. So I've bullet pointed there some of the things that the controller must, and again, it's a breach of the law not to do this, have in place by May. So what contracts have you got with third parties? That requires you to do a fair amount of auditing, and we've got clients that will have hundreds, if not thousands, of vendor contracts, and many of those do not have the appropriate language in to cover those things that I have bullet pointed here. So the takeaway from that is to be proactive in relation to your use of processors, to consider the contracts you currently have, to think about a new process for when you start negotiating for new contracts. You need to be doing due diligence. Does this third party that you are going to stick stuff in the cloud with have a history of breaches already? Have they been the subject of investigation? Are you actually working with the wrong vendor? How do they manage information security? Do they have ISO standards? Do they understand that if a data subject contacts the processor, they should not be responding to the data subject? It is your responsibility to respond. And I've had instances in the past where the contract didn't cover this, if there was a contract at all, and the processor, by trying to do the right thing, actually does the wrong thing, and the buck stops with you as the controller. And what's going to happen at the end of life to the personal data that is sitting with your host? Is it going to be destroyed? Is it going to be returned? Is it in a form that is capable of being used in any fashion when it comes back? Because it's still your personal data to be managing. So these things we didn't used to think about. And many of the third-party vendor contracts I've looked at don't anticipate this. But they're going to have to. Whether they like it or not, they're as liable, as I say, to comply as you are. I mentioned the other issue of international data transfers, and I don't want to spend too long on this. It's almost a talk in its own right. But remember, when data goes outside the EEA, the 28 member states plus Norway, Iceland and Liechtenstein, to any other country in the world that isn't approved, and that includes US, unless there is an adequate solution in place to protect the rights of individuals, it's a breach of the law. I still see some websites saying we are safe harbor compliant. Safe harbor has been dead for nearly 2 years. That is a misrepresentation. There is no safe harbor. There is the new version of it, which is Privacy Shield. But of course, Privacy Shield only covers data going from the EU to the US. It doesn't cover data that goes from the EU to Singapore or the EU to South Africa, in which case you have to look at some other solutions like the approved model contracts, or sometimes called standard contractual clauses, or the use of a group code of conduct, which we call binding corporate rules. And you could rely on consent, except that's precarious because consent can be as easily withdrawn as given. So we've got 2 other new ones that come up from May, which is codes of conduct or seals. There are, in fact, industry sector codes of conduct. So, for example, FEDMA, the Direct Marketing Association for Europe, already has a FEDMA code of conduct that all members adhere to. I am drafting codes of conduct for 2 other membership organizations where we're discussing it with the ICO. It's easier to have one code that everybody plays along with, subject to competition rules, than everybody going off to 25 different lawyers to get 25 different end results. So that is a route that is worth looking at. Or you go down the certification or the seal route, which is like ISO. And the French Data Protection Authority already provide a French seal, and you basically submit your compliance program to the regulator for audit. And if you tick the boxes, you get a big tick, and you market your compliance as a differentiator between you and your competitor. And I have one US software vendor that has gone for the French seal because they regularly respond to invitations to tender from the French government, and it ticks the right box instantly. They also have Privacy Shield and model clauses, but they've used a number of routes to help them comply. And again, failure to deal with this is one of those 4% fines. So if this wasn't depressing enough, I'm now going to head towards what's the worst that's going to happen. Well, we now have mandatory breach notification obligations where if there has been an incident and it might have a serious impact on data subjects, you have to notify the regulator, in our case the Information Commissioner's Office, within 72 hours of discovering the breach. We therefore need to make sure we actually have an incident response plan in the business so we know what a breach looks like, because failure to hit the 72 hours is an offence in itself. And I think that there will be, much like the US, a complete business around breach notifications and incident response and so on. We have to tell the data subject as well. So when we talk about what's the worst that can happen, if you've had the incident and you have to notify it, then you've got a right to all of the subjects who may have been impacted, and think about all of the well-publicized breaches recently by, Equifax and Uber and so on. You've now put your head above the parapet. You are now going to have very unhappy data subjects saying, I didn't even know you'd got my data. How are you doing this? Why are you doing this? I'm reporting you to the regulator. And it starts to go from bad to worse. Hopefully, you might be able to manage some of this risk by appointing a data protection officer, or at least somebody who has a compliance background. It's only mandatory if you're a public authority or you're carrying out activities that are regular and systematic monitoring of individuals, or you process what's now called special categories of data, which under the old law we called sensitive data, like religious background or religious belief, criminal records, health data, union membership, etc. So for many businesses, there will not be a need for a data protection officer, but that isn't to say that you might want to give somebody the responsibility to manage compliance, to manage the training as a defense mechanism for when the regulator comes knocking on the door. And the DPO has a responsibility for managing internal record keeping, like a risk register. We've never had this in the current law, and there is a requirement for every controller and processor to keep an internal record of processing activities. It's like a statement of, this is who we are, this is where we are, this is what type of data we process, this is why we process it, this is how long we keep it for, this is our data retention policy, this is whom we share it with, and here's all the processors that we outsource to. So there's quite a lot to think about in the records retention. And because we no longer have to register with the ICO, there will no longer be a public register that says who you are and what you do, which is why you now, as the business, have to be accountable and transparent and manage information. So I've just again extrapolated from GDPR what you need to think about mandatorily in terms of processing. And so the worst that can happen when you haven't done anything, as you can see, the 2% is not for data breaches. It's for not complying with the law, not having a data protection officer when you should have one, not having a suitable contract with your third-party vendor, not keeping that internal record. The 4% is for not complying with subjects' rights, for not managing international data transfers, and breaching the principles, which would be having a data breach because you obviously haven't managed the data properly, you haven't got adequate security in place, and so on. A lot of the media has focused on the 4%. And I just wanted to leave you with the even worst that's going to happen, which is that damn breach or that damn breach. And this is about the first time I'm going to talk about law. There's a case 200 years old in the UK called Rylands and Fletcher, and a farmer on the hillside who had cattle built a reservoir, not very well. It breached, the water flowed down the hill and crushed the crops of the farmer in the valley, and he sued. The decision in Rylands and Fletcher is this: if you are responsible for keeping in something which, if it gets out, causes damage, and you do not take reasonable steps to keep it in, then you are strictly liable. So all your limitations and liability clauses go out of the window. Your insurance cover probably goes out of the window. And this is where we're going to see the next PPI and whiplash claims. And there is already, because I found them on the internet, a data breach lawyers for you. They're not quite called that, but that's the sort of thing. I wouldn't use them because their privacy policy sucks. But essentially, they are saying, have you lost sleep because of where your data might be because of the TalkTalk breach? Have you lost sleep because of where your data might be because of the Uber breach? Has your grandmother lost weight worrying about you losing sleep? No win, no fee. We will bring an action on your behalf. And for the first time, the new law allows class actions like we have in the US. And I can see, if you take some of those well-publicized breaches, 114 million users times, let's say, £2,000 a person, makes 4% seem not that bad. And that, I think, is what's coming down the track and why this is a C-suite issue. This is a board level issue as much as anti-bribery, as much as anti-competition and antitrust type situations. So I do think this is what should be getting your management's attention. So take a deep breath. Understand what you've currently got, the who, what, when, where, why, and how, and then ask yourselves, are we actually complying with the current law now? Because I am still finding, as I say, statements about we rely on safe harbor. I've still got companies that are not registered with the ICO that should have been registered years ago. It costs £35 to register with the ICO. I just get on and do it if you're not on there, particularly as the ICO announced yesterday that from April of this year, fees are going up for being a controller or a processor. For the larger companies, up to £2,900 a year. I'd be trying to get in while it's still cheap, because at least you'll have bought yourself a year's cheap fee. On that, I'll say thank you and hand over to Rupert.
Thank you very much, Robert, for that. I see we have a couple of questions. The first one is from Sebastian, and that's: how much information will we have to provide from our CRM under right of access? Just the basic or the notes themselves? Now, the context here, I expect, is that we're talking about a user of a contact center with a CRM integration of some sort. That CRM, I imagine, is integrated in some way, Robert. And the concern here is that there's information in there that's been provided possibly under consent or possibly not.
Yeah, and the answer is that under the current law and the future law, you are only responsible for providing the individual with information on the personal data which you have about them. It is not about documents. It's not necessarily about the whole recording of the call. You could supply a redacted transcript, because you cannot give personal data about other people. It can only be relevant to the individual. And of course, some of the data you don't have to give them if they already had it in the first place, because they have the information at their end. You don't have to supply information that is legally privileged, something where there's already a dispute and you've been engaging with a law firm. You don't have to supply that, and you don't have to supply information that might harm a negotiation that you're having with the individual over a complaint. So they will not get what they think they're going to get, which is the smoking gun. But you will at least have to tell them, this is what we've got about you, this is when we obtained it, this is the means by which we obtained it, this is who we may have shared it with, and this is what was said. And of course, that's where often, with hindsight, you wished that somebody hadn't said something in an internal memo which you have now got to reveal about the individual. So I think we have a lot of tightening up that we could do in order to, as I said earlier, make sure the crisis does not become a disaster.
Yeah, and I think, we're talking about, in that instance, the question is in the context of CRM, which might be, fields of information. But of course, when we talk about multi-channel contact centers, we're talking about multiple media types, which we'll touch upon in a moment, because that adds another dynamic as well. So there's another question there. Which one are we taking, Emily? Okay, yeah, so this is from Paul. So the question is, where do the rules change between limited companies and sole traders?
They don't. A controller that has to comply with the law is any individual. So it's a sole trader, it's a partnership. It is an individual if they are processing personal data outside their household and domestic purposes. So as it happens, if you looked at my first slides, I'm not only a partner in a law firm, but I'm a notary public in my own personal practice. So as a notary, I have to run compliance as an individual. So I'm registered with the ICO, etc., and I am bound by all of the rest of this stuff in my own right. So for the corner store, the guy that's selling the newspapers and so on, he is as liable as Barclays Bank. And that is a challenge, because some of them have resources and the smaller guys don't.
Thanks, Robert. The next one is from Ishmael. Does personal data strong encryption at rest provide any relief or mitigation in the event of a data breach, assuming the attacker has only access to the encrypted data but is not able to decrypt it?
Absolutely, really good point to make. If you can't identify an individual from the information, it is not personal data. The law does not apply, and strong encryption at standstill, or indeed in transmission, would be a good risk management approach. The only risk is that, of course, if somebody is in possession of the key to decrypt, then the law will say it's still personal data. But I would certainly advocate looking at using strong encryption as a means of minimizing some of the risks. And if the data is hacked and the individual has encrypted information but can't decrypt it, you're absolutely right. There isn't a data breach.
Thanks. And the next one is from Stuart. If you handle a call for a client as a processor and deliver data to that client via email, we have no control over where that data goes geographically. What should the processor be considerate of in this situation?
So if I take it literally as you've described it, Stuart, if you are a processor and not a controller, most of the risk rests with your client. They're the controller that has given you instructions as to how you are handling a particular call. Once that data has passed from you, it's not your responsibility any longer. But that's where I would want to make sure that my terms of business adequately manage the boundaries of what we're responsible for and what you, the client, are responsible for. And again, that's not something we've necessarily had to look at in the past, but will do going forward.
Just to clarify on that, Robert, if you don't mind. So you're using the term a client. I think in the instance here, this is I suspect Stuart is running a contact center in his business and supporting a client who's actually the end user, the person concerned about their data. Are we talking about a difference in the answer there?
Yeah, so if in fact it's a call center within a organization and the client is part of a division in the organization, then everybody is the controller. Where the data then goes outside your control and ends up with a third party, you shouldn't have any liability, provided you've been transparent in your privacy notice that may be the way things work with somebody's data. And again, this is the lawyer speaking. Some things you can do to technically manage the risk, and other things are going to still be down to what do our T's and C's say.
Yeah, thanks for that. I'm glad that I sought clarification on that, and Stuart has confirmed that was the situation with his contact center. A couple more. Okay, so the next one is from Chris. Is there a burden of proof on an organization to show that a hacker can't, does that say can't, decrypt data? Yes.
And the answer is yes, there is.
Okay, short and sweet. And then, yeah, so I think what we'll do is we'll just step through a couple of slides that I wanted to cover, and then we'll allow you to answer a couple more questions because there are a steady flow of questions coming in. We'll give Robert a quick rest and just move on to a couple of slides in the context of Enghouse and, of course, Enghouse solutions. Just a moment to consider that Enghouse itself is a business, as well as the software and the solutions that our partners and our customers are consuming. And it's important to make a point, really, that Enghouse is treating this as seriously as any other business. We're taking the protection of that personal data very seriously. We have a plan in place for GDPR compliance, and we're working with all of the stakeholders within Enghouse. Now, Enghouse is a multinational, a global business, and so there are a number of entities within Enghouse who really are stakeholders in this process. And so, of course, in the process of doing that, we have to understand, the obligations regarding the data that we hold. Now, much like any of our customers running contact centers supporting customers, we also are supporting customers both in the form of partners and also the end users of our contact center and other solutions. So we are looking at, for example, what access to data we have in the process of supporting customers via remote access, for example, so being able to dial into remotely support solutions. What data we have to be able to perform financial functions, such as being able to charge for maintenance and so on and so forth. So all of those aspects and more are being considered and reviewed within Enghouse. So as a user of our solutions, and let's take a contact center as an example, what are the high-level steps that you should step through in the process of understanding where you stand within GDPR and where you should aim to be in the future? And I think at a very high level there are three stages. Firstly, the process of discovery, then of looking at consent. Now, I think, to be clear, we understand consent is not the be-all and end-all, but it is a very important part of handling personal data. And then looking at the way in which you process that data. Now, in the process of looking at the discovery, I think we've looked at the what, why, when, how, and where. I think looking at the context of a contact center, there are a number of pieces of information that you process in providing the service that you do. Contact centers are quite often integrated with other data sources such as CRM, but not limited to those, of course. And so it's important for you as a business to understand what information you process, and what types of information, what categories of information they fall into. And Robert referenced the standard data types as well as the sensitive data types. And it may be that the standard data types are more easy for you to be able to handle, but those sensitive categories are extremely important to be belt and braces. The question as to why you process that information is equally important. I think Robert, again, has gone into great detail as to why that's important. The reason for asking why you process it is, of course, well, if you don't need to process it, then you shouldn't be, and that avoids liability later on. In terms of how you process that information, well, that's down to the process of your business, and of course is different within every organization. Looking at how long that data is retained, that's a very interesting topic, and this process is leading everybody to consider why you might keep data longer than you should, and in fact it's not going to help keeping data beyond a particular date. There are examples of where you might store information for being able to call customers back and provide a follow-on service. But there's also the idea of the question as to why you would keep data on an historic basis when there's no need to do that. In terms of data's location, and of course I think Robert touched upon why that's important, and the regional aspect of data storage is even more of a topic of the moment, if you like, when we consider that our contact center solutions can be deployed in premise, in hosted, and also in cloud. And the Enghouse portfolio supports and offers products and services in all of those delivery mechanisms. So in terms of the type of contact center that you might be looking at from Enghouse, you will have different questions that you'll need to ask in terms of GDPR data, depending on the delivery method of your CC, your contact center solution. So I think several big questions there. And now, just to assist, Enghouse is working on the process of documenting what each of the contact center and other products handle by way of generic data. Of course, this is deeply subjective to every customer, but we are looking to document in a generic form what data fields our products handle, but that will be determined by the way that the software has been deployed. And so this is a business process, but we will assist in trying to document the products out of the box. In terms of the process of consent, well, this is an interesting one because, of course, consent can be obtained in a number of ways, depending on the media type that is being used. Now, Enghouse Interactive contact centers support multi-channel, and so, of course, the old school method of calling into a contact center and speaking to an agent, well, that still exists and it's still, highly relevant. And the process of obtaining consent, depending on the type of data that particular caller is giving consent for use of, will vary. So it may be a process of opting out if it's standard, reasonable data that is looking to be stored or used by the contact center. But if it's sensitive, then there'll be a more rigorous process that you need to go through by actively choosing to offer consent and also record that process, record that call. In terms of IVR, of course, there's an automated process which would need to be reported upon. And so the process of choosing one for consent or two not, for example, is something that would need to be recorded in the process so that there's evidence of that at a later date for auditing. From an email perspective, again, the process of consent will vary. And if there's no contract in place between the contact center and the end user, that person, whoever they happen to be they a financial customer, a citizen, a medical customer, or some kind of insurance customer, there should be a contract in place for that type of arrangement. If there's not, then the process of obtaining consent on an email basis is more rigorous and more long-winded. And then, of course, there are the other media types supported, such as web chat, which is very similar to email. Video is an interesting one because video by itself, the nature of video is such that because you're visible, you can be identified by your image. And so video, even though it's not so common in contact centers today, offers a whole host of other considerations because by the sheer nature of being on video, you have been identified. And then it's a good idea to look at how all of those things can be audited in your business. looking at the way that all of these media types and these considerations should be processed, I think Robert did a great job, and I'm not sure that I can add much value to that in terms of what you need to consider. It is about the way in which your data enters the business, the way in which it's handled, who processes it, where it's farmed out to or not, and the way in which the data flows between the different stakeholders within the business. So I think I should defer really to Robert's material there in terms of process policy, and in particular the industry guidelines on best practices. So finally, I think the takeaway really from this is that this is about process rather than technology. There is no such thing. There's no Y2K compliant product. There's no GDPR compliant product that will give you compliance. I think that's been quite clear from what Robert said. There's no silver bullet. This is a process of understanding, putting a process into place, understanding within your business what data, processes, contracts, diligence needs to be put in place, putting that plan in place and stepping through it, and above all, making sure that there's evidence of that plan from the beginning. And so from there, I think what I'd like to do is just go back and see whether there are any other questions. And I will look at, are we taking that one, Emily? I think we are. Right, so I think an anonymous question here. Do I need to, is that the one, the highlighted one? Do I need to ask the customer every time if he or she agrees that I process? It's gone off. Okay. Okay. Do I need to process? Do we need to ask the customer every time if he or she agrees that I process his or her data, purpose, retention period, possibility to be forgotten, or can the customer acknowledge or agree that once? So I don't need to ask this again, so I comply with GDPR. Sorry, I was struggling with the length of the sentence there. Did it make sense, Robert?
Yeah. Okay. And the answer is no, you don't have to ask every time, provided that the individual has been made aware at the first point of contact that there is a privacy notice that defines what you may or might do and what their rights are and so on. What I've advised lots of companies to do, and I've run it past the regulator and they've said that sounds good to me, is I would simply have on every touch point, for want of a better description, that you have with an individual, including on the footer of your email, signature block, on marketing material, on somewhere on there's a standard language on a call, for information on how we process and monitor your personal data, see more, or press 5, or whatever. And the ICO has said to me, I think you're doing everything you possibly can to draw the individual's attention to what you do with their data. I don't know what more you could do. And if you've led the horse to water, but it hasn't bothered reading it or drinking, that's the individual's problem, not really yours. So I think it just would be where you've got a regular customer, simply it would break the journey to have to keep going through the whole wretched thing. So no, there are other ways that you could achieve permission.
Thanks, Robert. The next question is, what does Enghouse do in their products to make sure that we abide by the law? For instance, delete someone who wants to be forgotten from all databases. So I think this is an interesting one. Firstly, I do need to repeat, the products themselves from any organization, whether you read it otherwise or not, are not product compliant with GDPR. That is not and will not be a feature of any product out there. GDPR compliance is a business process rather than any tick box in any collateral or brochure for any contact center solution. And you will not see Enghouse or anyone else selling that as a feature or a USP for one of our solutions. That said, our solutions have databases and structures that will allow a business to be able to report upon information that's available to them, and we'll be studying what is required in the market over time, and if there is a need to do any work on the products, then we'll be reviewing that. But at this point in time, this is a business priority within an organization and not a feature that needs to be deployed within a product. Next question is from Ian. Does the fact that call recordings do not reference the caller's number mean they are similar to encrypted records, as there would be the recording would theoretically be anonymous?
Yes, and if you look at the definition of personal data, it is any information that identifies an individual from that data, or from that data and any other information that would be reasonably in the possession of the business or the controller. So to take your specifics there, if there is hashing, for example, or ID that doesn't enable you from that ID and something else that you have to identify the customer, then it's not personal data. But there is, of course, the risk that by combining the ID number with something else, you can still identify, then you've got a personal data risk. But again, the more you can use technology to de-identify or pseudonymize an individual, the less personal data compliance you've got to worry about. And the regulators would say that's a good thing, because if it's not personal data, there's nothing to be hacked and lost, at least in terms of personal data.
Thanks, Robert. The next one is from Pat. As a maintainer of a contact center, if our client asks us to retrieve a call recording, are we then a processor of data, and what are our responsibilities under GDPR?
Yes, so this looks like a situation where the contact center is using you to do certain maintenance in your own right. And I would anticipate that in terms of a definition, this contact center is the controller, and you as the maintenance organization are the processor, assuming you're a completely separate legal entity. You have to act on the instructions of your contact center, and if therefore they're saying, by the way, we'd like you to retrieve a particular call recording, you have to act on that. But of course, you're not liable for what then happens afterwards, because it's still the contact center that's got the issue as to whether they should be responding to a subject access request, handing over an entire recording without redacting information or suppressing information about other people in it, etc. Just for the sake of levity for 1 second, the worst example I have seen of not understanding how to manage a request was where I had the chief financial officer of a investment bank in London ring me up and say, Robert, we've had a subject access thingy. And I think the word thingy gave it away that there wasn't actually a protocol in place. And I said to him, what's happened? And he said, well, you know, the Duchess of somewhere or other has died and she hasn't left a will, and now the son and daughter are arguing over who's going to get what, and the daughter has served a subject access request saying, I want to know what you've got on my late mother, and I want to know what you've got on me. And I said, well, of course, dead people's data is not personal data. It only applies to living individuals. So we don't have to reveal your late mother's data or the late mother's data, but give me 30 minutes and I'll ring you back. 2 minutes later, he's back on the phone to say it's all gone from bad to worse because one of the bank clerks has just handed over the physical file to the daughter with nothing redacted inside it, with a sticky label apparently on the outside that said, do we really have to hand this SH whatever over? And on the inside, which was even worse, was an internal memo between two bank clerks saying, this is the most revolting woman I've ever dealt with. You know it is just going to go from bad to worse. And of course, then suddenly afterwards, they get a protocol in place so that it doesn't happen again.
Next question is from Paul. Where do you stand if a partner collected the data, passed on to you, and then at a later date requested the data back, for example, working with channel partnerships?
If the partner collected the data, then the law would say they're the controller. If they pass it on to you, as a contact center and you are making independent use of it, then you're a joint controller. And therefore, it may not be feasible for you to pass it all back because you will have added value to some of the data that you've received, for example. But this again will be driven by what you put in the contract.
Right, okay, thank you. And I think this is probably our final question because we are about to run out of time, and it's from Martin. We see gift experiences through major resellers, Groupon, etc. The person who buys them then calls our call center to book their experience. We record those details and pass them to the photography studio. This is a photography gift experience. Where do we stand?
Yeah, and again, absent knowing what the contract says, it would strike me that you are acting as a processor for the photography studio, managing information they are giving you, and therefore it's primarily the photography studio that's the controller, unless you want to have better control over that data and make your own decisions in what you do with it. But again, that is something that you can define. I should also just add here that just putting in a contract something that says when we do X, Y, and Z, we are a processor, is not the entire solution, because when it all goes wrong, the regulator will say, I really don't care what you call yourself, let's look at what you were doing. And if you were acting independently of the other people that gave you the data, you are joint controllers, you are jointly liable, etc. So you need to be honest with yourselves as to what your actual role is. But then it's still the contract that hopefully is going to define your risk and liability vis-a-vis the, in this case, photography studio.
Okay, Robert, thank you so much for your time today. We very much appreciate you taking the time out for us. Would you like to just remind people of the Bristows company details?
I'd be delighted to. So yes, Bristows, based in London or headquartered in London. My email address is robert.bond@bristows.com. It's on the slides anyway. If anybody's got one-to-one questions, I'm very happy to receive those. And as I said earlier, in terms of that legitimate interest guidance, if anybody wants copies of those, I can certainly bring you up to speed with where we are on version 2. Thank you.
Thank you, Robert. And just a reminder, Enghouse Interactive is a leading supplier of broad portfolio of customer interaction solutions, including contact centers, attendant consoles, and quality management systems, but also a whole host of other technologies. We work through channel partners as well as selling direct. We're available through those channel partners and direct in most major regions of the world. You can visit enghouseinteractive.co.uk for more information or respond to the marketing material that you'll receive shortly. Thank you very much for your time. Thank you, Robert, for yours, and we'll talk to you all soon. Thanks again. Bye-bye.